So first, employers should start with having a good internal complaint procedure. Having a good complaint procedure opens up an affirmative defense for the employer that limits the employee's damages should they not utilize the complaint procedure put in place to stop harassment. Now, the affirmative defense is called the avoidable consequences doctrine, and it's recognized if an employer has a good complaint procedure that is really available for employees to complain, and there aren't any burdens or procedures in place or hurdles for the employee that prevents them from complaining. So having that good internal complaint procedure is key, really, to start with. And then second, when somebody complains, you have to treat all complaints seriously. Even these complaints, first blush, seem to be pretty insubstantial. You need to treat it seriously and follow through with all complaints. Don't ignore any complaints. And also, once the employer starts the investigation, it needs to get into the investigation immediately once the complaint's made by the employee. And I also recommend having two people involved in the investigation procedure. This gives the one person the ability to take notes and the other person to assess the witness's credibility when they're speaking to them. And also document that investigation well. I can't overemphasize how important it is to have good documentation of who you spoke to, what order you spoke to the witnesses, and what the witnesses said, and then what was done during the investigation. Now, in the investigation and documenting the investigation, you really need to use objective reasons in assessing credibility and determining what the next steps are going to be. And these are the credibility of witnesses, the demeanor of the witnesses. Do they have motives to falsify or lie to you? Do witnesses corroborate each other? And also past record of employees. Have other complaints like this been made, or have employees been known to lie in the past about certain things? All that comes into play and should be part of the documentation. Now, the EEOC actually publishes some guidelines on how to conduct sexual harassment, and I think it's good for employers to review that, and we'll have a link here on the screen taking you to those guidelines. And then also during the investigation, take a step back and determine, once you see the complaints coming and the allegations coming forward, is it something you have to address even before the investigation is done? And if it is serious allegations coming out, you still haven't made a determination, you should still address whether you need to separate the two employees before the investigation's done. And then finally, it's really important to prevent any kind of retaliation from occurring, and really re-emphasize that to everybody involved in the investigation. Even if you determine that harassment did not take place, but the person who the complaint was made against retaliates against the employee, there's still a cause of action there for retaliation, even though there was no sexual harassment. So that's also important to remember in conducting the investigation, that the company is not going to allow retaliation to occur. And should the employee feel like they're being retaliated against, they need to be told about how to complain about that as well.